She had not asked for a grand entrance. She had not worn her robe, flashed her credentials, or announced herself to anyone in the gleaming lobby of the Meridian Grand Hotel. Judge Naomi Carter, 48 years old, a sitting federal judge with 21 years on the bench, and a record so clean it had been cited in 3 law school textbooks, had simply walked through a set of revolving glass doors with a small rolling suitcase, a dark wool coat, and the quiet, unhurried manner of a woman entirely comfortable in her own skin. She was not looking to impress. She never was. What she wanted that Wednesday evening was ordinary: a hot shower, a firm mattress, and 8 hours of sleep before one of the most consequential trials of her career began the following morning. Instead, what Naomi Carter received inside the most expensive hotel in the city was a lesson she had not needed, because she had already learned it many times over, in many rooms very much like this one. The lesson was simple and brutal and delivered without apology. In certain spaces, in certain company, the color of your skin could make you invisible, or worse, it could make you a threat. The Meridian Grand stood 42 stories tall in the heart of the financial district, its facade a sweep of black glass and pale limestone that caught the late afternoon sun like a monument to its own importance. The hotel had been built in the early 2000s by the Aldridge Hospitality Group, a privately held company that had, over 3 decades, assembled one of the most profitable collections of luxury properties in the country. Its lobbies were designed to communicate something specific to anyone who entered them: that wealth was a language, and fluency in that language required proof. The carpet underfoot was the deep charcoal of polished graphite. The flower arrangements alone cost more per week than some families spent on groceries in a month. That evening, the hotel was preparing for a major gathering, a conference of finance executives and real estate developers, and one prominent sitting senator who had flown in from the Capitol, and the energy in the lobby was the particular hum of people who have never once questioned whether they belonged. Naomi walked in from the street and did not feel that hum. She felt, as she always did in rooms like this one, the quiet shift of attention that had nothing to do with recognition and everything to do with calculation. The front desk attendant was a young man named Marcus, though Naomi would not learn his name until much later. He had dark hair and a practiced smile that he distributed efficiently and unevenly. When the couple ahead of Naomi, white, well-dressed, carrying matching luggage with brand logos, stepped up to the counter, Marcus smiled wide and used both hands to process their check-in, making small, charming comments about the weather and the restaurant on the 39th floor. When Naomi stepped forward and placed her confirmation printout on the marble counter, something in Marcus's expression underwent a subtle but unmistakable recalibration. He looked at the paper. He looked at her. He typed something. He looked at the screen. He typed again. Then he said, with a tone that managed to be simultaneously polite and dismissive, that he was having trouble locating her reservation. Naomi told him calmly that the reservation had been made 3 weeks prior, that she had the confirmation number printed on the sheet in front of him, and that she was happy to wait while he looked again. Marcus typed once more, slowly, and then said he was going to need to get a manager. He said it the way people say things, when they have already decided the outcome and are only performing the procedural steps as a formality. The manager who appeared was a heavy-set man in his mid-50s named Gerald Howell, and Gerald Howell looked at Naomi Carter, the way some men look at weather they have decided to disagree with. He took in her coat, her suitcase, her posture, the color of her face, and the absence of any visible marker of status. No designer bag, no jewelry worth noting, no entourage. And he arrived at a conclusion before he had asked a single question. He said, in a voice pitched just loudly enough to be heard by the guests nearest the desk, that the Meridian Grand had very particular protocols for guest verification, and that unfortunately, without additional documentation confirming her identity and the purpose of her stay, he was not in a position to proceed with check-in. Naomi asked what additional documentation would be required, and whether this was a standard procedure applied to all guests. Gerald Howell's jaw tightened, almost imperceptibly. He said it was a matter of hotel policy. He did not answer her second question. And then, from somewhere behind Naomi, came a voice sharp, carrying, designed to be overheard, belonging to a woman, in a fur-trimmed coat standing near the elevator bank with a clutch purse and an expression of exquisite disdain. The woman said, at a volume that was not quite a whisper and not quite a declaration, that she simply did not see how someone dressed like that could be expected to afford a room at the Meridian. There was a beat of silence, then a sound that was not quite laughter, more of a collective release of tension, moved through the small cluster of guests who had been listening. Naomi Carter heard it. She had heard sounds like it before, in courtrooms when she was young, in parking garages, in department stores, in hospitals, in every space where her presence had been received as a question rather than a fact. She did not answer the woman. She did not raise her voice. She did not allow the expression on her face to shift by even 1 degree. She turned back to Gerald Howell and said very quietly that she understood he had made his decision, and she simply wanted to confirm that it was final. He told her that it was. She asked whether there was a formal complaints process she could access. He said there was a guest services number on the hotel's website. Then he nodded to the 2 security officers who had materialized near the desk, young men in dark jackets, who had the careful posture of people waiting for permission, and without another word, Gerald Howell turned and walked back toward his office. The security officers flanked Naomi at a respectful distance that was nonetheless unmistakably an escort. She gathered her confirmation paper, picked up the handle of her suitcase, and walked toward the exit with her chin level and her pace even. Several guests watched with their phones already rising. One woman in a green dress murmured something to her companion and shook her head. The revolving door completed its rotation, and Naomi Carter stepped out into the cool evening air of the city, alone. She stood on the sidewalk for approximately 45 seconds. The city moved around her, taxis, pedestrians, the distant noise of a delivery truck, indifferent, in the way that cities are indifferent to any single moment of private devastation. Naomi did not feel devastated. She felt the specific kind of exhaustion that comes not from surprise, but from repetition, from the accumulated weight of every other time she had stood in a space like this and been told, through gesture and policy and the careful architecture of exclusion, that she did not belong. She reached into her coat pocket and retrieved her phone. She called a number from memory. The call was answered on the second ring by her clerk, a young woman named Priya, who had worked with Naomi for 4 years, and had learned, during those 4 years, to read the precise register of her judge's voice with something approaching forensic precision. Naomi told Priya where she was and what had happened. She told her to contact the marshal's service and arrange alternative accommodations. She said it in the same tone she used to ask for a second cup of coffee. Then she ended the call and stood quietly, waiting. The car arrived in 11 minutes. It was a dark government sedan, unmarked but unmistakable, and it came to a smooth stop directly in front of the Meridian Grand's canopied entrance. The driver was a deputy marshal named Thomas, who stepped out in his uniform, walked to the rear door, opened it, and said with complete formality and no hesitation whatsoever, "Your Honor." He said it at a volume that carried. He said it to Naomi Carter, standing on the sidewalk with her small rolling suitcase, in plain sight of the doorman and the bellhop, and the 2 security officers who had escorted her out 14 minutes earlier, and who were now standing very still near the entrance, with expressions that had passed through confusion and arrived at something resembling dread. Several of the guests who had watched through the lobby's tall windows were watching still. One of them, a man in a charcoal blazer, could be seen putting his phone slowly back into his breast pocket, as if he had thought better of whatever he had been about to do. Gerald Howell appeared in the doorway. He had come out, perhaps, to make sure she was gone, or perhaps because someone on his staff had finally looked up the name on the confirmation and made the connection that no one had bothered to make in the previous 20 minutes. His face was the color of old wax. His mouth moved, but he did not speak. Priya's voice came through Naomi's phone. Again she had found the case file and was confirming the details that Naomi had already known. That the trial beginning the following morning at 9 o'clock in the United States District Court for the Southern District was Carter J. presiding, plaintiff being the Civil Rights Advocacy Coalition, defendant being the Aldridge Hospitality Group parent company of the Meridian Grand Hotel, this hotel, the one whose lobby she had just been removed from. Naomi accepted the folder of documents that Priya had arranged to have delivered, tucked it under her arm, and said only, over her shoulder, to no one in particular, and to all of them at once. Prepare the courtroom. Then she got into the car. The sedan pulled into traffic and was gone. What happened next inside the Meridian Grand was, by several accounts, not orderly. Marcus abandoned his post at the front desk. One of the security officers called the shift supervisor. The shift supervisor called the regional director. The regional director called the Aldridge Group's general counsel, a man named Richard Pratt, who had been eating dinner at a restaurant 6 blocks away. Richard Pratt took the call, listened for approximately 1 minute, put down his fork, and asked his dining companion, one of the hotel chain's senior vice presidents, to excuse him. The legal team that had been preparing for the next morning's trial had spent 3 months building a strategy premised on the idea that the Aldridge Group's internal documentation was clean, that the company's diversity initiatives were genuine, and that the plaintiff's claims of systematic racial discrimination in guest services were unprovable. They had been quietly confident. They were no longer quietly confident. It was important to understand what the Aldridge Hospitality Group actually was, because what happened in Courtroom 7 the following morning could not be fully understood without understanding the company that walked into it. The Aldridge Group was not merely a hotel chain. It was, in the estimation of its own annual reports, a curator of exceptional experiences, though the experiences it had been curating, for certain guests, had not been the kind that made it into the brochures. Over the previous 8 years, the Civil Rights Advocacy Coalition had documented 37 separate incidents across 11 Aldridge properties in which guests of color, Black, Latino, South Asian, Native American had been subjected to delays, denials, surveillance, removal, or humiliation that white guests, in comparable circumstances, had not experienced. The documentation was meticulous. Dates, names, photographs, security footage obtained through discovery, internal emails retrieved under subpoena, and the sworn statements of 9 former employees who had, at various points, been instructed by management to apply what one internal training document described, with remarkable candor, as discretionary guest screening protocols. 3 of those former employees had faced professional retaliation after raising concerns internally. 2 had filed their own separate complaints with the Equal Employment Opportunity Commission. Richard Pratt's team had spent considerable energy arguing that these incidents were anomalies, that no systemic policy existed, that individual employees had acted outside of company guidelines, and that the aggregate evidence was insufficient to demonstrate intent. The Aldridge Group's CEO was a man named Douglas Crane, 61 years old, a second-generation hotelier who had taken the company from his father's original 4 properties and expanded it into 32. Douglas Crane was not, in his own understanding of himself, a racist. He gave to diversity nonprofits. He had attended the right galas. He had approved, at least on paper, the company's equity and inclusion initiatives, which consisted primarily of a series of workshops, a dedicated webpage, and a committee that met quarterly and produced reports that were filed and not acted upon. He was, in the manner of a certain kind of executive, a man who had built systems that produced specific outcomes while maintaining sincere ignorance of what those systems actually did. He sat in the front row of Courtroom 7 on Thursday morning in a dark suit and a composed expression that had cost him a significant amount of conscious effort to construct. Naomi had risen at 5:30 that same morning at the government residence where she had been rerouted after the Meridian Grand incident, a modest but clean suite in a building used by visiting federal officials, and she had done what she always did before a major hearing. She had read the case file from the beginning. Not the summary, not the key exhibits flagged by her clerk. The whole file, start to finish, because she had always believed, since the early years of her career, when she was the only Black woman in rooms that were not designed to contain her, that the integrity of a ruling depended entirely on the quality of the attention brought to every page that preceded it. She made notes in the margins in her small, economical handwriting. She drank 2 cups of coffee standing at the window and watched the city skyline begin to resolve itself out of the pre-dawn darkness, tower by tower, lit window by lit window. She was not nervous. What she felt, in that quiet hour, was something closer to the alertness of a surgeon before a long and difficult procedure. Not anxiety about outcome, but absolute, focused attention to the work itself. She had been a federal judge for 12 years, and before that 9 years as an assistant U.S. attorney, and before that 4 years in civil rights practice, taking cases that paid poorly and mattered enormously. The law, when it worked as it was supposed to, was one of the few mechanisms available to people without inherited power for obtaining something like justice. She had taken that lesson seriously, in the way only certain people take lessons seriously, not as aspiration, but as obligation. The courtroom was full. It was the kind of full that happens when a case has been gathering public attention for months, press benches packed, observers in the gallery, law clerks and students lining the walls. The coalition's lead attorney, a woman named Simone Archer, who had been litigating civil rights cases for 26 years and had a courtroom manner that could be described, without exaggeration, as surgical, sat at the plaintiff's table with the particular stillness of someone who knows exactly what is coming and has no need to announce it. When the bailiff called the court to order and the door from chambers opened, every person in that room rose to their feet. Naomi Carter walked to the bench in her robe and sat down. She did not look at Gerald Howell, who was seated in the gallery, and who looked, at that moment, as though the floor beneath his chair had become unreliable. She did not look at Douglas Crane. She organized the papers before her, adjusted her reading glasses, and looked at the room over the rims of them with the full, level attention that had been her professional signature for more than 2 decades. Then she said, "This court is in session. Today's proceedings concern evidence, not emotion. Counsel, you may proceed." The testimony began with a former Aldridge employee named Kevin Desmond, who had worked as a front desk manager at one of the company's flagship properties for 6 years, before resigning after being told by a superior to stop logging certain types of complaints in the official system. Kevin Desmond was 52, soft-spoken, and precise. He testified that during his time at the company, he had been explicitly instructed, on multiple occasions, to apply what was called a VIP calibration to new arrivals, a process that, in practice, meant assessing the likelihood that a given guest would spend money in the hotel's premium services and amenities. He testified that this calibration, as it was applied by the staff around him, correlated directly and consistently with the race of the arriving guest. He testified that he had raised this concern 3 times with his direct supervisor, twice with the regional manager, and once in an email to the Corporate Human Resources Department, and that he had received, in response, a performance review that rated his interpersonal communication skills as needs improvement for the first time in 6 years of otherwise exemplary evaluations. Simone Archer walked him through each of these points with the patience of someone laying bricks. The defense attorney, a polished man named Harrison Cole, cross-examined him with vigorous skepticism, but Kevin Desmond had anticipated the skepticism and had documentation for everything. Then came the emails. Obtained through discovery after months of litigation, a series of internal communications between regional directors and the corporate operations team painted a picture that Richard Pratt's careful framing had not prepared the defense table to address. One email, dated 4 years prior, from a regional director to a property manager, used language that made Harrison Cole visibly uncomfortable when Simone Archer read it aloud. It referred to maintaining the property's guest profile and ensuring that services were allocated in a way that protected the brand's positioning. A follow-up email, sent 2 weeks later, included specific reference to the difficulty of managing certain situations at the front desk when the lobby was busy with conference guests. A third email, from a corporate vice president to a director of operations, said flatly that the issue of verification protocols needed to be applied more consistently to avoid situations where individual managers were making decisions that could expose the company. The word verification appeared 14 times across the email chain. The word race did not appear once, but the pattern that the emails described was unmistakable to anyone reading them in sequence. Then the video arrived. It had been obtained from a combination of the hotel's own security archive partially, because significant portions of the footage from the relevant time period had been deleted or corrupted, and from the personal devices of 3 guests who had been in the lobby and who had, in the intervening months, decided to cooperate with the plaintiff's investigation. The video showed the lobby of the Meridian Grand. It showed Naomi Carter entering, It showed Marcus at the desk. It showed Gerald Howell. It showed the woman in the fur-trimmed coat. It showed everything with the impartial, flat, unhurried clarity of a camera that had no investment in the outcome. Harrison Cole objected to its admission with considerable force, arguing that the presiding judge had a personal connection to the events depicted, and that its introduction constituted an irreparable conflict of interest. He argued it with confidence because it was a reasonable argument and because he had not yet understood who he was arguing it to. Naomi Carter listened to the objection without interrupting. When he finished, she was quiet for 3 seconds, a silence that had a particular quality, the quality of a door closing very precisely in a very well-built frame. Then she said, "The objection is noted. The court will address it directly. This video is admitted not as evidence of any personal grievance of this court, but because it is probative of the behavioral patterns that constitute the central claim in this case. What it depicts is not my experience. What it depicts is company policy operating in real time. The video is admitted. Proceed, Miss Archer." The room was very quiet. Several people in the press gallery were writing quickly. Douglas Crane had stopped looking composed. The plaintiff's team had also saved, with strategic deliberateness, a document for last. An internal audit commissioned by the Aldridge Group itself, 2 years prior, that had found significant disparities in service outcomes across guest demographics and had recommended a full review of front-of-house protocols. The audit had been received by the executive team. It had been marked confidential. It had not been acted upon. It had not been disclosed during the pre-trial discovery phase, a fact that Simone Archer raised with quiet, devastating precision, and which prompted Naomi Carter to say, with no audible emotion whatsoever, that she would be addressing this matter separately. By the time the second day concluded, the expression on Douglas Crane's face had passed through composed and arrived at something that resembled a man doing arithmetic he did not like the result of. His general counsel leaned over to him twice during recesses and said things in a low voice that Crane received with the rigid stillness of someone who has been told that the emergency exits are on the other side of a very large fire. On the morning of the third day, Naomi Carter read her ruling. She read it without preamble, without performance, without any of the rhetorical gestures that some judges use to signal the magnitude of what they are about to say. She read it as she read everything clearly, precisely, with full attention to the language, and none to the theater. The court found that the Aldridge Hospitality Group had engaged in a pattern of systematic racial discrimination in the delivery of guest services across multiple properties over a period of not less than 8 years. The court found that this pattern was not the result of individual employee misconduct, but of institutional policy explicit in some instances, implicit in others, but consistent in its effect and its targets. The court ordered the company to pay compensatory damages of $173 million to the plaintiff class, which included more than 340 individuals who had been identified as victims of the company's discriminatory practices. It ordered the payment of punitive damages in the amount of $65 million on the grounds that the company's conduct, including its failure to disclose the internal audit, demonstrated willful and sustained disregard for the civil rights of its guests. It ordered the establishment of an independent oversight committee with authority to monitor the company's compliance with a mandatory anti-discrimination training program across all properties for a period of 5 years. It ordered a full operational audit of the company's front-of-house protocols, and it referred the matter of the suppressed internal audit to the Department of Justice for investigation into whether the company's pretrial conduct warranted further legal action. She did not mention the Meridian Grand lobby. She did not mention Gerald Howell, or the woman in the fur-trimmed coat, or the security officers, or the quiet sound that had moved through the crowd when a woman who had not asked for anyone's permission to exist in that space was told, without legal basis or human decency, to leave it. She mentioned none of it because none of it was necessary. The law did not require her to be wounded. It required her to be right, and she was. Douglas Crane sat for a long time after the courtroom began to empty. His attorneys gathered their documents with the practiced efficiency of people whose next task is to begin managing consequences rather than preventing them. Harrison Cole shook Crane's hand briefly, a gesture that had the quality of a formality completed rather than a comfort offered, and then he was gone. Crane remained seated. He was, by any reasonable measure, a man who had just watched the architecture of a very large thing collapse, and who was only beginning to understand that he had been standing inside it. The hotel itself moved through its consequences with the speed that follows public exposure. Gerald Howell was placed on administrative leave within 36 hours of the verdict and terminated within the week. The investigation that followed his departure discovered that the deletion of security footage from the lobby on the night of Naomi's arrival had been authorized by Howell personally, a fact that his attorney was currently engaged in the complicated work of explaining to a federal investigator. The woman in the fur-trimmed coat, a socialite, whose name became attached to the story after one of the lobby videos circulated widely, did not face legal consequences because cruelty is not always a crime, but she faced the particular modern punishment of being recognized everywhere she went by people who had seen what she had said and decided they did not want to forget it. She issued a statement through her publicist. The statement was not received warmly. Several of the charity organizations she had supported quietly declined her continued association. It was not justice in the formal sense, but it was a reckoning of a specific and persistent kind. The former employees who had testified were, to varying degrees, vindicated. Kevin Desmond received calls from 3 civil rights organizations offering him consulting work. He accepted one. The other 8 former employees who had cooperated with the investigation were named as additional plaintiffs in a supplemental action filed by Simone Archer's firm, seeking damages for workplace retaliation. The Aldridge Group stock lost 31% of its value in the 5 trading days following the verdict. 3 members of the board of directors resigned within 2 weeks. The board, acting with the urgency of people who had suddenly discovered that their house was on fire from the inside, appointed an interim CEO and announced a comprehensive review of company culture, policies, and executive accountability. Several major publications examined the case and its implications for the hospitality industry more broadly. Law schools added the ruling to syllabi. The specific finding on the suppressed audit and the referral to the Justice Department that accompanied it prompted 2 other companies in unrelated industries to voluntarily disclose internal audit findings that had been similarly buried because the cost of discovery had just become very clear. It was impossible to say, with any precision, how much the ruling changed. Change is slow, and it moves through institutions the way water moves through rock, not by force but by persistence. The Civil Rights Advocacy Coalition had been building this case for 4 years before it reached Naomi's courtroom. The lead organizer, a man named Robert Hale, who had spent 30 years documenting discrimination in housing, employment, and public accommodations, had begun receiving complaints about Aldridge Properties shortly after the company's aggressive expansion into the luxury market in the early 2010s. The first complaint came from a retired physician named Dr. Margaret Owens, who had been celebrating her 40th wedding anniversary at an Aldridge property in a coastal city and had been asked by a security officer unprompted while she and her husband were having a drink in the hotel bar to produce identification. Her husband, a retired engineer, had not been asked. The second complaint came 6 weeks later, from a family who had been told their confirmed reservation was unavailable and who had watched, from the lobby, as a comparable room was assigned to a white couple who arrived after them without a reservation. The pattern became clear enough that Robert Hale took it to a civil rights attorney named Claudette Marsh, who took it to Simone Archer, who took it to the federal court system, and began the long, expensive, methodical work of building a case that could not be dismissed, deflected, or settled cheaply into silence. What Richard Pratt had not accounted for was a former Compliance Department employee named Sharon Wells, who had kept copies of documents she had been instructed to destroy. When she came forward near the end of discovery, she arrived with a hard drive and a very good memory and a lawyer of her own, and everything the defense team had told Douglas Crane about manageable exposure became, in the space of one afternoon, no longer accurate. Naomi returned to the city on an autumn afternoon 7 months later, on different business, a conference at the law school, 2 blocks from the Meridian Grand. She had no particular intention of going in. She walked past the entrance once, on her way to the conference, and then, after the conference ended, and the evening was still early, she walked back. She was wearing the same dark wool coat. She had the same small rolling suitcase because she had an early flight the next morning. She walked through the revolving door and crossed the lobby to the front desk. The lobby had changed new carpet, a slightly different arrangement of the flower arrangements, a small placard near the concierge station, listing the hotel's current community partnership organizations. The front desk attendant was a young woman, maybe 25, with a calm and attentive manner and a name tag that said Delia. Delia greeted Naomi with the kind of warmth that does not come from a script, the kind that comes from having been trained not in procedures but in people. She pulled up the reservation efficiently, confirmed the details, offered a room on a high floor with a city view, and asked if there was anything else she could arrange for the evening. Naomi asked, almost as an afterthought, whether the new training program had made a difference. Not who she was, not why she was asking, just the question. Delia considered it for a moment with the seriousness it deserved, and then said that she thought it had, that the thing it had changed most was not the procedures, but the way people understood what they were for. She said the thing that had stuck with her most was a single line she had written on a note card above her workstation at home. She said, "We learned that dignity has no dress code." Naomi took her key card. She thanked Delia. She did not tell her who she was. She crossed the lobby, entered the elevator, and rode it to the 31st floor in the company of a businessman on his phone and an older couple consulting a folded paper map of the city with the absorbed concentration of people who are seeing something for the first time. The doors opened. She walked down the corridor to her room. She set her suitcase by the window and stood for a moment, looking out at the city, the lights of the financial district, the dark ribbon of the river to the south, the 1,000 illuminated windows of 1,000 ordinary evenings. She did not feel triumphant. She did not feel vindicated in the way that stories sometimes suggest a person should feel at the moment when the arc has completed itself. She felt what she usually felt at the end of a long day of doing the work, tired and clear, and ready for what came next. Robert Hale said in an interview, 6 months after the ruling, that the thing he hoped people understood about it was not the damages figure or the oversight mandate, but the legal articulation of what systemic discrimination actually means when it operates through institutions that have learned to deny it. He said the ruling had given future plaintiffs and future attorneys a framework, a vocabulary, a standard of proof, and a judge's own voice saying clearly, "This is what the pattern looks like. This is how you establish it. And this is what the law says about what must follow." He said it quietly, the way people say the things they have worked longest to make real. Naomi, when someone told her what he had said, did not comment. She was already working on the next case. There was always a next case. That was the nature of the work. That was, in its way, the whole point. Because justice is never about the moment of reversal. It is not about the CEO who sits in an emptying courtroom doing arithmetic he does not like. It is not about the manager who loses his job, or the socialite who finds her charity connections evaporating, or the stock price that falls 31% in 5 trading days. It is about the person who comes after the next woman who walks through the revolving door with a small suitcase and a confirmed reservation and a perfectly ordinary expectation of being treated like a human being. It is about whether, when she steps up to the front desk, the person on the other side of the counter has internalized something true, that every person who enters deserves the same threshold of respect, regardless of what they look like, what they are wearing, or what assumptions the room has already made about them before they have said a single word. That is what the case changed. Not the carpet, not the placard, not the language in the company's equity statement, or the composition of the board, or the careful phrasing of the interim CEO. What it changed was a standard. And standards, when they are enforced with the full weight of the law and the quiet, unshakable authority of someone who understands what the law is actually for, have a way of outlasting everything else, the people who violated them, the systems that enabled the violations, and the comfortable silence of everyone who watched and said nothing and went home. Real power does not raise its voice. It raises the standard for everyone, and it does not lower it again. She had been carrying that understanding since before the law had given her a formal instrument for it. Growing up in a mid-sized city in the South as the daughter of a postal worker and a school librarian, Naomi had absorbed the texture of unequal treatment, not through abstraction, but through proximity, through watching how her parents moved through spaces that were nominally open to them, and in practice, something more conditional. Her mother had told her once, when Naomi was perhaps 12, and had come home furious from an incident at a department store in which a security guard had followed her through 2 floors. While white shoppers her age moved freely through the same space, that dignity was not something another person could give you, and not something they could permanently take, but that the law, the actual law, applied by actual people, committed to its principles, was one of the few forces that could require others to honor what they were inclined to dismiss. Her mother had been a careful woman, not given to dramatic statements, and so that sentence had stayed with Naomi the way careful sentences from careful people do, not filed away, but active, a kind of internal reference point that she returned to without consciously deciding to. She had thought about it, briefly, on the sidewalk outside the Meridian Grand, standing in the cold with her suitcase. She had thought about it in the government sedan on the way to the federal residence. She had thought about it somewhere around 2 in the morning, when she woke from a shallow sleep and lay in the unfamiliar room listening to the city outside and deciding, as she had decided before in other difficult circumstances, that the appropriate response to injustice was neither silence nor performance, but precision, precise attention to the record, precise application of the law, the kind of work that does not make for dramatic stories in the short term, but that builds, over time, a body of precedent that is harder to erode than any single verdict. That was what her mother had been trying to give her, not consolation, but a tool. Naomi had spent her adult life learning how to use it. The case itself had been remarkable for reasons beyond its immediate outcome. It was, legal scholars would later note, one of the most fully documented cases of institutional discrimination in public accommodations to reach a federal court in the previous 2 decades. The statistical evidence alone, the analysis showing that guests of color were denied, confirmed reservations at a rate 7 times higher than white guests at the same properties during the same period would have been sufficient, under the applicable standard, to establish a pattern. But the documentary evidence that accompanied it went further, establishing not merely the pattern, but the mechanism, the internal communications, the suppressed audit, the training protocols that had been designed to function as screening tools while maintaining the appearance of neutral policy. What made the Carter ruling particularly significant, in the estimation of the scholars who would later analyze it, was the clarity with which it articulated the distinction between institutional intent and institutional effect. The principle that a discriminatory system does not require explicit racist intent at the level of individual decision-makers to constitute a violation of civil rights law. What matters is what the system produces. What matters is who it harms. That articulation, stated with the precision and restraint that characterized everything Naomi Carter put into writing, gave future litigants and future judges a framework that would be applied in contexts well beyond the hospitality industry. Douglas Crane eventually gave an interview, several months after the ruling, in which he spoke of the experience of the trial, with the careful, managed contrition of someone who has been advised by counsel to express remorse without admitting to things that might create additional legal exposure. He said that the company had failed to live up to its own stated values. He said that he had been unaware of the specific practices documented in the case. He said that the new leadership was committed to a different approach. The interviewer, a journalist who had covered civil rights litigation for 20 years and who had very good instincts about the difference between contrition and management, asked him whether he believed that systemic discrimination could occur in a company without the knowledge of its CEO. Crane was quiet for a moment. Then he said yes, he believed it could. The journalist printed the exchange without further comment. It did not require one. Simone Archer returned to her office the week after the ruling and began working on the next case, which involved a different company and a different set of victims, and the same essential pattern that she had been documenting in different forms for 26 years. She was not surprised by any of it. She had never been surprised by any of it. which was what made her good at the work and what made the work, on the worst days, genuinely difficult to do. What she had found, over those 26 years, was that the moments that kept her going were not the large verdicts. Those were satisfying, in the way that finishing something long and difficult is satisfying, but the feeling did not last, but the smaller, more specific moments when the record made permanent something that had previously been deniable. When a document entered evidence, and a company could no longer pretend it did not know. When a former employee spoke on the record and could not be pressured back into silence. When a judge wrote a ruling that said, with the full authority of the federal court system, this happened, it was wrong, and here is what must follow. Those moments accumulated. They built something. The work was slow, and the progress was real, and both of those things were true simultaneously, and living with that was what the work required. Priya, Naomi's clerk, filed the ruling with the court system at 8:47 in the morning on the Tuesday following the close of testimony. She printed a clean copy, placed it in the case file, and set the file in the stack of completed matters. Then she went to get coffee. On her way back, she passed Judge Carter's chambers and saw, through the open door, that the judge was already at her desk, reviewing the record for the next scheduled hearing. Priya stood in the doorway for a moment and said, "The ruling's filed." Naomi looked up, nodded once, and returned to the record in front of her. Priya went back to her desk. It was, in its way, the only kind of ceremony that the work ever got, and it was enough. The independent oversight committee that the ruling mandated held its first meeting at the Aldridge Group's corporate headquarters on a Monday morning in late winter, in a conference room with a long oval table and a view of a parking structure. The committee was composed of 5 members: a former federal civil rights investigator, a sociologist who specialized in organizational bias, a hospitality industry expert, a community advocate from one of the cities where the discrimination had been most extensively documented, and a retired judge who had been appointed as chair. They spent the first meeting reviewing the company's submitted compliance plan, which ran to 62 pages and addressed, in considerable detail, the procedural changes the company intended to implement across all 32 properties. The committee chair, the retired judge, asked a series of questions about the plan's enforcement mechanisms. What happened when an individual property manager deviated from protocol? Who was responsible for logging complaints? What consequences existed for retaliation against guests who raised concerns? The company's compliance officer answered each question carefully and at length. The chair listened, made notes, and at the end of the meeting said that the committee looked forward to reviewing the implementation data at the 90-day mark. The meeting lasted 2 hours and 40 minutes. The committee would meet 12 more times over the following 5 years. Some of the meetings would show genuine progress. Some would reveal backsliding that required corrective action. All of them would generate records. All of them would be filed. That was what oversight looked like in practice. Not dramatic, not triumphant, not the stuff of headlines, but a steady, documented insistence that stated commitments be honored, repeated at regular intervals, by people who did not intend to be dismissed. Naomi Carter did not attend any of those meetings. She had signed the order that created the committee, and she had moved on to other matters, as was appropriate, as was required. The oversight was not her work. It belonged now to the people appointed to do it. Her work was the next case, and the one after that, and the careful, patient construction of a record that said, in language precise enough to withstand appeal, this is what the evidence shows, this is what the law requires, and this is what must happen. She had been doing that work for 21 years. She intended to keep doing it, not because she was indifferent to outcomes she was not, had never been, but because she understood, in a way that was not resignation and not cynicism, but something more like clear-eyed persistence, that the work did not end. The cases were not solved. The pattern did not disappear because a single verdict addressed a single instance of it. What a verdict did, when it was good, when it was careful and grounded and resistant to sentiment, was establish a point on the record that future people could use, a benchmark, a standard, a line in the documented history of what was allowed and what was not, written in the language the law understood, available to anyone who needed it. She had told a law school class once she gave a guest lecture every few years at the school where she had studied. as a way of keeping herself connected to the purposes that had brought her into the work, before the work had become routine. That the thing she wanted them to understand about federal litigation was that it was not primarily about the individual case. It was about the accumulation of cases. It was about building a record that was harder to erase than any single ruling. She told them that the discouraging thing about civil rights law in particular was that each generation of litigants found themselves arguing against the same essential structures with slightly different faces, and the encouraging thing about civil rights law in particular was that each generation of litigants had a better body of precedent to argue from than the one before. She said that every good ruling was a gift to someone who had not yet been born, who would face a situation the ruling's author had never imagined and would find, in the language of an old decision, exactly the language they needed. The students had written things down. Naomi had gone back to her chambers and continued working. That was what justice looked like from the inside. Not a feeling, not a moment, a practice repeated, documented, imperfect, absolutely necessary, carried forward by people who understood that the standard existed only as long as someone kept holding it, and who intended to keep holding it for as long as they were able. Dignity has no dress code, a young front desk attendant had said on a quiet autumn evening in a hotel lobby that had once been a site of humiliation and was now, in its slow and incomplete and real way, something different. The words were simple. They had come from a training document. They had become, for one person, a principle. And principles, when they are genuinely held and genuinely applied, have the same quality as the rulings that enforce them. They outlast the circumstances that produced them. They travel forward into rooms the people who spoke them will never enter. They arrive before you, and they hold the door. That is what Naomi Carter's work had always been about. That was what it would always be about. That was, in the end, enough. She thought about the woman in the fur-trimmed coat only once more after the trial. Not with anger, not with the particular bitterness that is sometimes mistaken for clarity, but with the detached curiosity she applied to most things she did not fully understand. She wondered whether the woman had understood, in the weeks after her image circulated and her associations began quietly dissolving, that the harm she had caused was not personal in origin, but systemic, that she had not invented the contempt she expressed, but had merely voiced, in a hotel lobby, in front of witnesses, what many such spaces had been communicating through policy and procedure for years without anyone having to say it out loud. She wondered whether that understanding would have changed anything. She thought probably not. The understanding that harm is structural does not, by itself, produce the willingness to stop participating in the structure. That requires something more, something harder to arrive at than comprehension alone. She did not pursue the question further. There were other questions, better posed, waiting on her desk.